Good evening, everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanthi Reddy to discuss the latest updates on immigration, the latest DOL and DHS rules that are turned down by the court, and we also have I-485 that continued from the last session. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We'll start taking calls in a few minutes. Before starting the show, I would like to repeat the disclaimer. Please note, this show does not provide any legal advice. It is very general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any ways for your actions. Use this information at your own risk. Hi Prashanthi Garu, how are you doing?
Hello, how are you? Ranjit, I'm good, thanks.
I'm good, Prashanthi Garu. It's been a good week. We have some good news for H1B people who are out there, who are confused, who are in a lot of stress, and also a lot of employers as well as attorneys are worried about what's going to happen with the new DOL rules that are already in place and new USCIS rules or DHS rules that's supposed to come on December 7th, I believe. I believe it's overall a very good news for everyone. Could you please shed some light on what happened and what did the court do and when will all these be effective and all? Can you please go ahead?
Yeah, sure. So basically what has happened is there were two, I think in our last session we had discussed there are two court cases pending. There were two court cases. One was in San Francisco and the other one is in Washington, DC. So this one, we received the summary judgment yesterday, I believe, which basically, this is the San Francisco court, and they have given a summary judgment. So basically, they didn't even go into the long merits of the case, or they didn't go into detail or have, cross motions. So they gave a very brief judgment. Usually that happens when there's no issues or when the court is not, is not in two minds or needs more information. If the facts are very clear, then they usually just give a summary judgment, which is a quick, kind of a quick judgment. So in this case, just to remind our viewers, it was almost a death threat for H1Bs because there were two things. The Department of Labor came up with regulation. Both happened simultaneously, USCIS regulation and Department of Labor. So the Department of Labor regulation said that the wage levels were increased significantly, almost double, which pretty much means that 50% of the H1s can't be filed or more maybe. And it was in the increase in the wage level, there was no adherence to fact, or there was, usually when they look at wage levels, they can't just decide, okay, this is going to be the wage level. It has to be based on industry standards, and that was not done. They just arbitrarily decided on certain numbers and decided that these are the four wage levels and these are the wages. So for example, level 1 wages for an IT position, they said was 150,000 in New Jersey, which is ridiculous, right? Because nobody gets that for an entry level position. So it was not based on any facts or any criteria. The second regulation that was going in, the DOL regulation has already gone into effect. So in the last few weeks, we really haven't been able to file H1s, and we have not been able to file prevailing wages to start the green cards, to file the labor certs. Both have been on hold. So the second thing that was worrisome for H1s was that on December 6th, the new law, that the regulation with reference to specialty occupation and with reference to right to control was coming back into play. So there was a court case whereby the right to control, the whole issue was defeated because they said it was against the law. So then they came back with a regulation and they said that right to control is still an issue, and if the person is working at a third-party work site, then the employer has to show that they have the right to physically control that person and control their employment, supervise them. And there was a whole tedious documentation requirement, with contracts, employment agreements, right to control language. And, 50% of the RFAs were based on this right to control concept. And we were, for some months, we had some respite because of the IT Serve court case. They had to take out that whole right to control. So they were bringing it back in the form of a regulation, basically an interim final regulation. And the same thing with specialty occupation. Specialty occupation, there was already an issue, and we're continuing to have an issue, but they were codifying it in the form of a regulation so no one can file a lawsuit in the future. And they were basically saying, and they were also changing some things from what they're doing right now. So one thing they were saying is that specialty occupation, it has to be a specific specialty, which means that if you're filing a case for like a systems analyst, and as per the Occupational Outlook Handbook, which is, a Department of Labor book, which is available online, if the job requirement is a bachelor's degree in computer science, engineering, and different fields, related fields, but different fields, then that position is not a specialty occupation. It should only say computer science, information technology, so something specifically related. If it says engineering, then they're saying it's too vague. So they're saying those jobs are not specialty occupation. As a result of which, many IT jobs became declassified and they were no longer specialty occupation. So that was a huge problem for H1s. So we were left with only a few jobs, really 3 or 4 jobs where, in which we could file H1s and the rest we couldn't. So the wage issue, the specific specialty occupation issue, also the specialty occupation, previously the standard was that most employers should require a bachelor's degree in a specific field. And with this regulation, they changed it to all the time. So all employers should require a bachelor's degree in a specific field. It's not enough if you show that a majority of them require a bachelor's degree in the industry. All employers should require. So that is a very, very hard thing to prove, that every single employer requires a bachelor's degree, right? So these are the changes, and they're very significant changes that would have really diluted the H1B program to a great extent. So because of this, 2 lawsuits were filed. And one of the lawsuit, which is the San Francisco, the case filed in San Francisco, was decided, and they didn't even go into the merits of whether this wage level, the DOL wage level was justified, whether it was unconstitutional, whether it was based on fact. And they didn't go into the specialty occupation, whether their interpretation of the specialty occupation is based on the Immigration and Nationality Act or not. They just said that both these regulations are based on interim final regulations, which means they didn't go through the entire regulatory process of publishing a regulation. This usually takes 6 months to a year if you have to go through the entire process. They did an instantaneous regulation. That's why it's called interim final. And in order to do an interim final regulation, you don't have to go through the comments period. You don't have to go through the publication period. So it's kind of a shortened timeline. So you have to justify that. You have to justify the shortened timeline, and you have to basically say that there was good cause or there was some urgent need, and which is why you couldn't wait until that, the entire period is over for the way you actually do a regulation. So the comment and the publication period was done away with, and so you have to justify why it was done away with. So the government, the USCIS and DOL gave some justification, and they basically said that because of COVID, there's an economic downturn. And there's an economic downturn even in the occupations that use H1s, specialty occupations. So therefore, because this is so time sensitive, because COVID is happening now, we don't really have the time to wait for 6 months, 1 year, then there's no point in doing it, which is pretty much their main argument was that. So as a result of which, the basically the court, the judge has said that number one, they have said that they don't believe that there is any good reason or good cause, because they have pointed out that the economic downturn due to COVID has not affected the IT sector and other specialty occupation sectors like healthcare, etc., the way it has affected the other sectors. So in the other sectors, while the unemployment is 10% or 11%, in the IT sector or the other business sectors, it's only 3% to 4%. So they believe that there is no justification for not following the law with reference to, how a regulation should be published. And second, they have said that there has been delay on the part of the Labor Department and the USCIS in publishing the law, because what they said, and which is true, is that in 2017 itself, the DOL wage changes, the proposal has been put into the agenda. So what was the reason for them to wait since 2017 and then suddenly come up with it now? So there's a delay on the part of DOL in publishing this regulation. It was not something that was thought of now, but it was thought of in 2017. And even if we put aside the 2017 publication, that, the proposed publication, they had since March to do this. And there was no reason to wait until after, the first wave of COVID was over to do it. So they're saying there's delay on the part of DOL in USCIS, and they could have easily done the proper publication process if they would have started earlier, and they had enough ample opportunity to start earlier. So based on these two grounds, they have said that there's no good cause for, the publication to be done in such a hurry, to do it as an interim publication. So as a result of which, now it's really a relief that the wages again will go back to normal wages, so which is 70, 75K, 85, for entry level position in, New Jersey and, these areas, California, etc., which is more normal, right? It is also the same as industry standard. Previously, if the employers used the new standard, then they would actually might have to go to court for other reasons, because other employees who were not H-1Bs would take them to court, because you have to pay employees equally. So permanent residents and citizens would end up being paid less, and H-1B visa holders would end up paying more. So that is really not a desired, result. So basically now the wage levels are more industry standard. So that's a great relief, and people can file as usual. And the other big relief is right to control has been taken out. So they cannot ask for documentation with reference to the contracts between all the parties. They cannot ask for, to show supervision when the person is working from a third party work site. So these are huge problems that we were having in the past whenever a person is working at a client site in an IT situation or even a healthcare situation. So they cannot ask for that anymore. And also the specialty occupation, they have at least struck it down. So they don't have it in a regulation form now. So they can still apply that, but it's still back to the old standard of, as long as most employers require a bachelor's degree, that position would then qualify for a specialty occupation. So yeah, Ranjit, all in all, it's very good news. Everybody is kind of breathing more normally now, and because earlier it was really stressful. As I said, filing H1s were becoming almost impossible. So now it's back to normal, better than normal, in fact, because even the old right to control regulation has been removed.
Yeah, that's pretty good news for at least many people and even the employers, because the rise in wages is not like it's small. It's very huge. It was almost from level 2 to level 4, which a lot of companies can't afford in such short time. Yeah, and one more thing, Prashanthi Garu, when do you think these are going to be effective? Are these effective immediately?
So basically, with reference to right to control and the specialty occupation, USCIS will not be able to publish that, implement that regulation on the 6th. So that is effective immediately. With reference to DOL wages, they've already implemented it and they've already published new wages. So we need the wages in order to file an LCA or a prevailing wage approval or a H1. So we have to wait for the Labor Department to revert back to the old wages on the FLCA data. So we're hoping that will be done soon, that they will do that immediately, because the new wages are no longer valid. So they have to revert back to the old wages. So we're waiting for them to do that. We're hoping that will happen soon.
Yeah, another thing that's concerning a lot of people is, do you think that USCIS, DOL or DHS going to appeal this? Because same thing happened with the public charge rule. It was gone again, it came back, then again court stopped it, and again they appealed it. Do you think, is there any chance that they are going to appeal it and get a stay and continue having these rules?
So the good thing is that they don't have much time, right? The government is changing. And the new government, I will not be interested, I think, in doing all these restrictionist policies towards, legal immigration. They may not undo what is done so quickly, but they're definitely not going to spend their energy doing it for sure. So they have to actually file an appeal. So, and then continue with the court case. And that requires them to stay in power, right? So I doubt there will be enough time. They would have definitely appealed if they could, if they had the time, but I don't think there's enough time to do that.
So yeah, the other topic that we had missed in the last session because of the time constraint is the I-485. Apart from that, we have completed all other stages. So could you please, go ahead and say what is I-485 and, what is the significance of it? What all the documents that are needed and what is the filing process? What is the turnaround? What are the timelines and all?
Yeah, so basically just to go back to our last session and sum it up, we are right now on the green card, employment-based green card module. And last session we had discussed how to file a labor cert, right? And then how to file the I-140 and what are the different kinds of, what is the process that needs to take place before a labor cert can be filed? What are the likelihoods of an audit, and what happens when the labor cert gets audited? And what are the usual things that people are asking? The Labor Department is asking in an audit. Nowadays, audits have actually increased because I guess of the perception that unemployment is on the rise. So audits with reference to labor certs are asking about recruitment efforts. They're asking you to show that you have actually done all the advertisements, and that if you have received responses, they want an entire detailed recruitment report. And then once we get the recruitment report, you have to show how many resumes.
Hi, Prashanthi Garu. I think we have a caller, I believe. Let's.
Hey, hi Ranjit. Hi Prashanthi Garu.
Hello?
Yes, go ahead.
Hey, I've seen this last evening. What was the court judgment? I have my LCA which has been opened last week, which is yet to be approved. So because my start date is from December 8th. So what do you suggest, Prashanthi Garu? Would you like to go ahead with the existing LCA, or you want me to wait for a week, postpone my start date and get a new LCA on the new rates which are going to be changed sooner?
So if you have no issue with the rate right now, based on the present LCA,
I should not say this. I'll put my information confidential because I have to pay back my employer because of the wage system.
So then that is not at all an ideal situation to be in. My suggestion is definitely wait for the new LCA wages to come out, then file a new LCA, and then file your H1 if you're able to postpone your start date.
Yeah, do you think one more question, because mine is an extension and also there was little changes. So one more question added to this. Do you think the rate ranges would be decreased with the current, or they would be the same thing which were there in the past?
They would be the same thing what was there in the past, because the wages just increased in June. Every June they come up with new wages based on what the situation is that year and inflation, etc. So whatever was in June, that will be the wages.
Okay, it's not like something these days, because I'm from Jersey, the wages were around 72 or 73. Usually it was around 48. But is that not something it goes to from 72 to 55? Not like that. It should be the same as it was before the October, right?
Right, that's correct. Whatever wages were in June, July, that's the wages. In July 1st, starting July 1st, actually. Yeah.
Oh, okay, fine. No problem. Thanks, Prashanthi.
You're welcome.
Yeah.
Okay. Okay, Prashanthi. Yeah, sorry, that was an interruption. We can go back to our I-485 topic.
Right. So I was talking about the labor cert and the what's happening with audits, and they're asking for to submit detailed recruitment reports showing why people, if they were applicants, why those applicants were why the applicants were basically rejected, and they're asking for detailed detailed analysis on that. And they're saying that, okay, if they were rejected based on the lack of certain skills, why couldn't the employer have trained, given training in those fields, in those skills? So basically the way we show that is that we show that the training requires a lot of money. Basically it's expensive, and also the duration of the training is pretty lengthy. So it's not possible for it's very, very onerous for the employer to provide training, because these are specific skill sets. They're not simple things that the employer can train. They have to be trained by qualified professionals. So they have to get certifications. They have to go to institutions to get these kind of skill sets, because they're so complex. So that's how you show that, and that's how you justify with reference to the labor cert audits. The other thing they're asking in the audits is, of course, with reference to sometimes they're asking if the employer has paid, or the employee has paid the employer to place the ads, or they're asking for an affidavit or a statement stating that there's no payment, there's no transaction that went on for the labor cert. So these are the few questions. Then they're asking if, why, and if it's an EB2 case, why an advanced degree is required, and why a bachelor's degree is not sufficient. So you have to show, again, the complexities of the job. It's a business necessary letter that has to be prepared. So these are few hurdles that are faced when there is an audit. And since the audits are increasing, I thought I would touch upon those hurdles with reference to the labor cert. Though we did go through the nuts and bolts last time, we didn't really touch upon these advanced issues. So the other thing that could happen is during an audit, they can find out that maybe. Yes. Is there another call? Yes.
Hi, Prashanthi.
Yes, please. Hi.
Yeah, my name is Srijana and I'm calling from Texas.
Okay.
I have a question regarding to the recent rule change. I have been seeing in the show that the wages have come back to normal. So I have one question here. My last year, I have done a transfer to an employer B, wherein generally the employer initiated the LCA for 3 years. But for some other reason, I got my H1B transfer approved only for 1 year. Now that the wages have been taken back to the old rates, so will I be able to use the same LCA for next extension, or do I need to still go ahead and file a new LCA again once the rule changes starting from September right of the month?
Right. So that's a good question. You can reuse the old LCA, especially if you don't have time to wait and your H1 extension is coming up. But if you have time, then I would rather you just file a new LCA. So anyway, so I think that's what you keep your other documentation ready, keep your H1 documentation ready. And, as soon as the wage change happens, file the LCA. If there's not enough time and the LCA doesn't come on time and your I-94 is expiring, then file it with the old LCA. You can absolutely do that. But if you have the time, it's always prudent to have, a new LCA. Because maybe the wages might have changed a little bit, especially since June, since the wages have changed. You don't want to get an objection on that basis.
My H1B is actually expiring next Monday. So my employer actually wanted to put the petition tomorrow. So as the new rule did not come into existence still, do you think like the USCIS would accept if in case they still use the old LCA and send it?
Yeah, so the old LCA was filed a year back?
Yes, they filed an year back.
But you only have 2 years on that LCA, correct? So you can only file for 2 years. You can't file for 3 years.
Yeah, just 2 more years left.
And has anything else changed with reference to your job? Anything on that LCA has changed? Client, work site, anything else? Nothing has changed. So my suggestion is then,
no material.
Go ahead and use that old LCA and file your H1 because you don't really have time now.
Okay, but they don't reject it, right? Without the rule actually coming into existence from 8th of this month?
No, the only issue is not about the wages because the wages, are turned back as of the date of the hearing, the decision. But the only issue is that you're using an old LCA, but we have always done that in the past. We have always used old LCAs and there's never been an issue because sometimes when there's something wrong with the new LCA and then if the employer has an old LCA and which is not being used, as long as the LCA is not being used, USCIS does not have an issue with, using an old LCA. So as long as it's not 10 years old and it's, 1 year old should be fine. So I would go ahead and do it because we've done it in the past. We have not had an issue.
Yeah, sure. Thank you so much.
You're welcome.
Prashanthi, I think we have another caller. Let's take this call. Hello.
Hello.
Yes, please go ahead.
My name is Silas. I have a question regarding my I-797 has been lost a couple of days back. So I was talking to my employer and he was just saying we'll do it in a week. But I just have a question because my employer was saying there were some fees which is to be paid. So I just want to talk to Mr. Prashanthi Reddy on that.
Right. So what is your question?
So my employer was saying there were some fees which I have to pay.
Yes, that's correct. There is a fee that has to be paid. That has to be paid by your employer because it's a H1 process. So it's a duplicate. When you file a duplicate petition, you have to file an application. When you ask for a duplicate approval, you have to file a petition, I-864, I believe. So the I-864 form has to be accompanied by a fee. I don't remember how much it is, $300 or $400, I think. And so
my question is, I have to pay that or my employer is going to take care of it?
Your employer has to pay because it's a H1. You didn't pay your H1 USCIS fee, right? This is the same thing.
No, because this was, he was mentioning here, I can do a check on Department of Homeland Security with, he was mentioning
you cannot. No, you cannot. You cannot pay the filing fee. If you're talking about no, you cannot pay the filing fee. The filing fee has to come from the employer. If that is your question, that is very clear. The answer is very clear.
He was mentioning I can do a check with 465, something like that number he mentioned, and he was saying he'll give the exact number by end of tomorrow.
No, the petitioner has to file. The petitioner has to write a check to USCIS. They will not accept a check from you if it is a duplicate filing for a H1.
Okay. Thanks.
It depends on what the duplicate filing is for. So duplicate filing can be for a family-based case. It can be I-539. In that instance, then yes, the beneficiary can submit the check. But if it is for a H1, I think it is prudent for the petitioner to submit the check. That is my suggestion to you.
Okay, fine. Thanks for handling it. Thanks, Ranjit.
If anyone wants to reach the attorney Prashanthi Garu for a private consultation, please reach her at 212-354-1010 or prashanthi@reddyesq.com. Before going into the I-485 topic, there is one question that we got from the Facebook. What happens, the people who have already filed the extensions or amendments or whatever using the LCAs that were already approved between October 8th until now? How are those cases adjudicated?
So the problem is that those cases will be adjudicated as per the LCA. So if you want them to be adjudicated as per, it's adjudicated as per the LCA filed at that time. So if you used the new wages at that time because that was required, then they would be adjudicated according to that. So if you want to use the new wages, then you have to withdraw that and then refile an LCA based on the the old wages, and then refile the H1, because you cannot change a H1 that has already been filed, because the LCA should have been approved before the filing of the petition. So you can't file an LCA now and try to interfile it with the H1, right? So unfortunately, to remedy that situation, you'll have to refile the H1 if you can, and if you're not falling out of status. Then that's one way of doing it. Or you could just get an approval and then maybe after that file an amendment based on the new wages. You could do it that way as well.
Okay, I think we have another caller. The number starting with 202, ending 1057, 202-854-1057. You're on the air. Please go ahead.
My name is Vijay. I have a question, how about new H1s, Andy? New H1s for the next year, will there be any change on that, or going to be like earlier, like lottery system and everything is as normal as before?
Right. That's a good question, Vijay, because that's another impending regulation. Until the present administration leaves, they will continue torturing us with new regulations. So that's another impending regulation. They're basically talking about doing away with the lottery system and going with a new system whereby the people
merit system.
Yes, whereby not really merit, it's based on wages. And they want to do it based on wages. So the higher paid people will get more preference, and the lower paid people will get less preference. So pretty much that's the end of all entry level. F1s are not, mostly H1 cap is used either by people outside the country or by change of status. So, and a lot of them are F1s, students. So that is really bye-bye to students, and which means bye-bye to universities, because nobody will come to those universities.
So it's going to be like this, or so
the regulation hasn't. The regulation hasn't been published yet. It's in the agenda, and they're saying it's going to be published. So maybe because of this court decision, they will backtrack. Because again, if they publish it, they're not going to do it. They don't have the time to do a full publication and notice and comment period like they should for a regulation. So they will try to do it quickly as an interim regulation. And if they do that, again, it's going to be challenged in court, and no court is going to accept it now. Keeping in mind that, there is already a court decision on this case, with reference to whether COVID is a justification for, changing or publishing a regulation without comment and comment period.
Okay, so the answer is to wait and watch.
Correct. I doubt even if it comes that it will be successful, because remember, this is March. The new cases, cap cases we're talking about is March. So by then, the new administration will take charge. And there will be a court challenge, even if that happens. I mean, even if the regulation is published. So I think it's not going to go through, but it can definitely make our lives more difficult, because then someone has to file a court case, it has to be decided. So let's hope it doesn't happen. And I'm hoping that the San Francisco case acts as a deterrent for the present administration to continue, on their path.
Okay, Andy. Thank you so much.
You're welcome, Vijay. Take care.
Yeah, one quick announcement. Whoever on the conference call, if you would like to talk, please press *6 to be in the queue, and then I can then let you in to ask a question. Oh, I think we have a caller. Yes, the number starting with 602-315-5450. You're on the air. Please go ahead and ask your question.
Yeah, hi Ranjit, hi Prashanthi. So thank you very much for all this information. I listened to all the details. My question is that, my green card was applied in EB2, and then the priority date is 2017. And I'm with the same employer since last 15 years with a bachelor's degree. And they said to me that from EB2 to EB1, it's better that you wait, until some time, and then we can try to push your case. And this is ongoing since last 4 months, and they were expecting that there should be a change in the government, which is the case now. So what is your assessment in terms of the timelines? I mean, does it make sense to start the preparations for the LCA and getting all the letters of verification right now, so that the ball can be rolled in the month of February? Or do you think that no, I should wait for another 3, 4, 5 months to do that?
So can you first explain to me what you're planning to do? Did you say EB1?
EB2 to EB1, yes.
So on what basis are you planning to file the EB1?
Because I got promotion here, and I'm a manager here, and I was also doing the managerial work there. But so that is an EB1C category.
So you qualify. So you're basically saying that you qualify for an EB1 based on that multinational executive, right? Is that what you're looking at?
Right. Exactly.
So then pretty much what has to be done is an I-140 has to be filed for the multinational executive. But even EB1 is not current. But obviously it's better than EB2 or EB3. EB2 is the worst. EB3 is better right now, as you know. But I don't see what is their purpose to delay if you qualify. I think you should go. I mean, you should file an I-140 with EB1. There's no harm. At the most, it'll get denied, but you still have your EB2. If you file the EB1 based on I-140 and it gets approved, you can interfile your current 485. You can, first of all, port the priority date, and then it's going to be current anyway. And then you can interfile that with the present 485, and you should be able to get your green card in the next, 12 months to 18 months. Then it's just the processing time for the 485. And most probably your 485 is already, processed to some extent. Maybe they'll have to take fingerprint, they'll have to take medicals again, or maybe they'll look into it to see if there's any documentation needed. So it's definitely a good idea to go with EB1 if you qualify. There is, nothing to think about that, really.
So, yeah, okay,
no harm.
Thanks for that.
There's no harm.
It's not about, there's no harm, okay. And with the change in the government, I think it should be anyway helpful that, some people were saying that they'll not be like, they issue a lot of RFEs, in the last 6 months. So it should be better going forward.
Right. And if that's your concern, then you should maybe wait for a few months next year until the new USCIS director takes over and see how adjudication is. It's not going to change that much, but at least it's not going to be drastic. You can expect it. During Obama's time also, they were not free with their approvals. there were issues. So it's basically a question of whether you qualify or not and what documentation you're able to submit. That's pretty much it. But if you're worried about the present administration, present USCIS kind of mindset, then wait until next year and then file.
Okay. Thank you very much. Thanks.
You're welcome.
The number starting with 402 and ending 7892, Harish, you are on the air. Please go ahead.
Hi, Prashanthi Garu.
Hi, Harish.
Harish. So, yeah, I have actually applied for H1B and it also picked in the lottery. Recently, I upgraded the premium processing in the end of October month, but I don't have any response till today. Even my employer reached out to USCIS regarding case status, but no response. But an hour ago, I got an update from USCIS in the online stating that my fee will be refunded, but still there is no update on the case status. I mean, whether it is an approved or an RFE. So what could be the possible outcome here, and what should be made further steps?
Well, it could be that premium processing, they don't require it because maybe the case decision was already made. And therefore, there is no purpose in accepting your premium processing fee. So they are refunding it. That's possible. That most probably is the case. Or it could be that they cannot process it via premium processing because there's some issue. So it could be one of these two. So it's difficult to say. Is it an extension?
No, it's initial.
So change of status from F to H or something?
From the F1 to H1B. From F1
Right.
to H1.
Right. So as long as it could, and when did you file it?
File it in July. Yes, in the month of July.
And then you converted it to premium processing recently?
In October.
In October.
Yes, October.
So it could be that the decision has already been made. It could be that the decision has been made and therefore they are returning your, premium processing fee. So that might be good news because if it's an RFE, they will still continue. They'll take your premium processing fee and still continue. If it's and it can't be a denial because they don't deny cases without an RFE. So maybe it's an approval. So wait and watch.
But it has been 37 days, right? Within H1B premium, like they should be receiving an update within 15 days. But even though we calculated federal days, it would be like 24 days around. If it is an approval or RFP, I don't have any update yet. So
I think you need well, basically the only thing you can do is wait. But I'm just suggesting making some educated guesses. That's all we can do at this point. And giving you various reasons why you're seeing what you're seeing. The other reason for not being able to premium process it is maybe if there is fraud involved, right? And they want to do further investigation. Then also they would, since they're going beyond that the time, they have to refund the premium processing fee then. Right, and which is what they're doing because they were not able to process it within that period of time. So that could be another reason also, another explanation. Or, for whatever reason, they're doing some further investigation and they're not able to process it within that time period. And therefore they're returning your fee and then they will take the regular processing time to process your case.
So the time period that will be taking process my case will be still a premium or?
No, it will not be premium. It will not be. It will be regular.
Okay. All right. Thank you.
You're welcome. Good luck. I think we left off at labor audits. And I was, saying that in case they find that there is some issue with the recruitment or that, maybe resumes have come and the employer is misstating the facts that resume have come and the employer is saying that there are no resumes, or if the ad is such that labor department thinks that at least there should have been some resumes and the employer is saying there are no resumes, it's possible that they can conduct supervised recruitment. which pretty much means that the ads have to be placed again, and there is a reference number given, which has to be put in the ad, and then the resumes go directly to the labor department, and then the labor department will send the resumes to the employer, and then they have to conduct the recruitment, contact those applicants, go through that process again. So most probably when they do that, they only ask you to redo the newspaper ads, not all the ads all over again. So you have to go through that process again, and then if you're successful, then the labor cert will get approved. So that
Prashanthi
is
garu,
another
sorry to interrupt you. We have a caller, Vasu, number starting with 602 and ending 9959. You are on the air. Please go ahead.
Yeah, thank you. Thank you, everyone, for your time. This regarding, I recently filed my EB2 to EB3 downgrade. I'm just curious to know, I mean, how long is going to take usually for I-140? I mean, it's subject to time, your estimation time for I-140 approval for EB3 I-140, then corresponding 765 EAD. Once EAD is approved, usually for how long we need to work with employer? Is there any restriction once we get EAD? Minimum
So
6 months,
basically,
1 year we need to work with employer.
So you filed your EB2 I-140 and you filed the 485 together, or I-140 is already approved?
Together. For EB2 I-140 I already have. Now recently, my priority date was 2014. So we have filed concurrent filing, adjustment of status with EB3 I-140 and AOS.
So
approximately your yeah.
Right. So if you want the I-140 to be approved faster, you can do you can try to do premium processing, but they might not accept it because they don't have the original labor cert. I mean, they have it, but they are not premium processing the cases in which you don't submit the original labor cert with the I-140. That's what has happened for us as well in few cases. But maybe that will change. So you just keep a watch on that and see if things change with reference to them accepting premium processing for for downgrades. And if it does change, then you should go ahead and file, convert that to premium processing. Then the processing time is much more predictable. But otherwise, it could take, right now it's just taking a month just to get receipts, which is not a good sign. Yeah. So for them, because they have literally thousands of applications, they have I-140. If you don't, premium processing usually takes 4 months, 4-5 months, but maybe now it'll take a year. Who knows? For them to go through everything. And then if there's an RFE, then there's an additional delay. And it's most likely that they will not process the EAD until the I-140 gets approved. That is possible as well. And they may not process the 485 and the related documents until that I-140 actually gets approved. That's how they usually do it. Because then they will issue EADs, and then they'll, it's a waste of everyone's time then, if the initial I-140 gets denied. So that's how I'm thinking that they will do it. But in general, once the I-140 gets approved, and it's been 180 days since the 485 has been filed, both have to happen. I-140 approval and 180 days since the 485 has been filed. Then as per AC 21 regulations, you can change your employer to any other employer with a similar position. Doesn't have to be the same position, but it can be similar position. And you can do that by filing a 485J.
Okay. 180 days. Okay. Thank you so much. Yeah.
Okay. Thanks for the call. Please, if someone wants to speak again, please press *6 or *6. And Prashanthi, there is good news coming that S386 bill is passed.
Oh, that's very good. Very good news. Wow.
I'm just seeing some news from. Okay, I think it's few seconds. So as of now, there is no objection. So looks like there is no debate, no objection from any senator, and looks like it is passed. This
That is
opens. If this
amazing
is
news, Ranjit. Yeah.
Yeah, if this is real, hopefully we'll get update probably in maybe before the end of the show. If this is real, then a lot of people are going to be very happy. A lot of people will get green cards. To sum up, S386 is the bill that will remove the country cap uh, discrimination, which has India only has 7%, the same China and all other countries have 7%. With the bill passed, if this bill is passed, no, there is no country cap, and it's like first come first serve basis. But then there is some transition period, I think about 6 years, in which some percentage will be still allocated for ROW.
And I think that might have been changed to 9 years. So I don't know what the final version of it is. We need to look into that, and maybe that's a topic for
Next
our next show
topic.
next week. But definitely
But
good news, Ranjit.
this is a very huge news. I mean, a lot of people will be happy with, you know, dates will progress faster now, because, and also the other thing to add, people will also be able to apply for I-140 who have I-140. People who have I-140 will be able to apply for EADs. Child's age will be logged, and a lot of other things. So it's a very good news for everyone. I believe this is time to celebrate. A lot of people, yeah, it looks like it is passed. I mean, I'm getting a lot of messages from. I'm also in one of the advocacy groups where they were messaging. So I think yes, looks like the bill is passed. We have to wait for the final text to see what the bill exactly has. But to sum up, one of them is to lift the country cap, and the other one is getting the EADs for family. And the other one is the kids protection. One thing to remember, that this bill, since it is passed after October 1st, it will only be effective, I believe, in the next October 1st. We will confirm that in the next show. But yeah, that's what it is for now.
Right. So, I mean, with reference to the passing of this bill, now it's kind of hard to predict what effect it will have on Indian nationals. There'll definitely be some forward movement. But because of the restrictions with reference to, that window of 9 years or 6 years or whatever it is, whereby certain percentage of numbers, right, are given to all other countries. So 20% of numbers will be reserved for all countries, and then the rest will be, I guess, equitably distributed among different countries.
First serve. Yeah.
First come, first serve, right?
Yeah.
So it may still not be enough for Indian nationals for them to be current, right, Ranjit, as per your statistics?
Not all will be current, but then as we know that 140,000 green cards are allocated every year. Now that, right, let's say the 25% is taken off from it, assume there are about 100,000. That's a huge number. We only have about 10,000. Now it's 100,000. That becomes.
Maybe there'll be another forward movement of 5 years.
Yes, but then it's a good news that at least the other thing, as Biden administration said, that they'll also be going to increase the number of green cards. If that happens, that's again a huge boost. But as of now, something is better than nothing, because this bill is on the floor forever.
It actually was set to expire, right? So because it had a 2-year time limit, it was set to expire in December
4th. I think January 4th or January 3rd was the expiry date. I don't remember, but it's January 1st week was the expiry.
Yeah.
Now it happened and it's passed. And other thing we have to remember here is people will get EADs. Everyone knows that EADs are far better than the H1Bs, and you don't have to worry much about when adjustment of status is pending. Even let's say the H1B is not there, you can still stay in the country legally. And even though you cannot work until you get an EAD, but at least you can stay in the country. And moreover, a lot of people are struggling is kids aging out. A lot of people who are aging out will now be protected. That's a good news for all.
That is amazing
Parents.
news, right? Because they have been waiting for last 10 years and children have. I wonder if it'll help people who have already aged out. Maybe not, but at least it'll freeze the age of people who are going to age out.
There are lawsuits for the cases where the kids already aged out, saying that they should be protected retroactively from the I-140 priority date, but we don't know what's going to happen to that. But then as of now, as we said, immigration reform is a must need of the hour. At least, things are moving forward, and, and it's a very, very good news that people get to be at peace, at least for some time.
Right. So let's wait and see.
We will come up
how
with
it
a whole
actually.
text. Whole text probably. We'll see if we can plan another show anytime sooner, or if not, then the next show. Definitely we'll come up with each and every detail, because it has lots of clauses. From what I remember, there are lots and lots of clauses.
Right.
Some clauses
and also they've those clauses have been changed again in August. So
there have been a lot of changes. I don't know even now if there are some new changes from the last one. So we have to just wait and see what's going to happen. I think we are at the end of the show. I don't want to take much time, but again, Prashanthi Garu, thanks. We'll come up with a new show, or in the next show, we'll give up what are the clauses and how it's going to help everyone. Hopefully, this will help a lot of people, and it's a good news today. A lot of good news just this week.
Yes. And after a long, many months of bad news, I think we are suddenly getting lots of good news. So we deserve it.
Light at the end of the tunnel.
End of the tunnel. Correct.
Okay. Thanks everyone. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Wednesday at 5:30 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday, 5:30 p.m. EST on Sakshi TV. This is Ranjit signing off. Thanks everyone. Bye-bye.
Thank you.